Welcome to this presentation, our first in which we will discuss age discrimination. So let's begin. After our introduction, we're going to discuss the ADEA, which is the major statute in this area. It's a federal law, and we'll discuss the related laws in this area. Then we'll discuss the process by which a complaint goes through the administrative process or the administrative system and can ultimately lead to a lawsuit. And we'll also discuss the Prima Facie framework and how it differs between the Americans with Disabilities Act, the Age Discrimination and Employment Act, sorry about that, and Title VII. So let's go ahead and begin. You probably already know this, but if you don't, age discrimination is a real thing. It affects people's lives. It is a pretty serious problem in the United States. There's lots of age discrimination cases that are filed every year. Once upon a time, it used to be that employers were allowed to have mandatory retirement ages. For the most part, those are no longer lawful. We'll discuss the couple of categories of exceptions to that. Generally, our population in the United States is aging, and so we should continue to see um, the number of age discrimination cases increasing as our population ages. Research indicates that sometimes older workers are undervalued in the workplace. Sometimes there are assumptions about their skills. For example, people think they may not be as technologically gifted or they might not stick around as long as other workers might be. Oftentimes, older workers can be more reliable, can be willing to put forth more effort, and may have higher attendance, although obviously that stereotype is not true for every single case. There are lazy old people just like there are very hardworking younger people. And generally, when we talk about discrimination in employment, we want to keep in mind that those stereotypes that we have, whether they're positive ones or negative ones, are not going to apply in every situation. And so, one of the things we look for when we're talking about looking at an individual employee is how is that particular person working, not how does most people in his or her employment category work. So we want to individualize the consideration and not apply generalizations about that person. Age discrimination in employment is different from uh, sex and race and national origin and religious discrimination in that there is no reverse discrimination permitted or claims permitted. I guess reverse discrimination can happen, it's just not a legally defined category. Age discrimination in employment does not permit reverse discrimination claims, nor does the Americans with Disabilities Act permit reverse discrimination claims. So, what do I mean when I say reverse discrimination? That is when the person in the majority category or in the more favored social category is able to file a claim just as somebody who is not in a socially favored category. For example, men can file age claims. I'm sorry, men can file sex claims just like women can. A Caucasian can file race claims just like African Americans can. Um, uh, People who are Christian can file claims just like Jewish people can of religious discrimination. So those are examples of reverse discrimination. But we do not have a claim for reverse age discrimination under federal law. Here's an example to illustrate that point. So Bob is 22 and he's a security officer. His manager decides to fire him not because Bob's doing a bad job, but because Bob is young, and the manager replaces Bob with Larry, who's 54, simply because the manager feels that older workers generally are more reliable and hard working than younger workers. Again, he's applying a stereotype and not individually analyzing Bob and Larry. Under these circumstances, I can understand Bob feeling very frustrated about the situation, but he does not have a colorable claim of age discrimination under the Age Discrimination and Employment Act. Similarly, he would not have a claim under Texas state law. There are some states that do recognize reverse age discrimination claims, but not Texas. Naturally, when we look at the age 40 as the point at which age discrimination begins under both state and federal law, There's a big difference between somebody who's 40 and somebody who's 90. And so there's the recognition of that distinction in the case law that is developed in this area. Um, Everybody who has had his or her 40th birthday is protected from age discrimination, but there's a recognition that an employer might not discriminate against 40-year-olds, but might well discriminate against 70-year-olds. Another thing that's important when we consider this class is that they reflect people at different points in their lives. A 40-year-old, for the most part, unless he's or she's an athlete, probably hasn't had a lot of diminution in coordination or speed or other mental processing, memory, things along those lines. But a 95-year-old who's working isn't likely to be as spry as a younger person, may not have as quick a mind or as good memory as a younger person. That aging process is going to hit all of us at some point, and as we get older, there will be some diminution in functioning. And so that's kind of an inevitable part of the human experience. So people from 40 to the point in which they retire are going to be at various levels of skill, and those things don't happen at the same time for every person. There's some people who may experience some of those declines in their 40s. Other people might be very, very spry and fit well into their 70s. Another issue can be that people who are older workers, people in their, say, 50s or 60s, are oftentimes more highly compensated. After all, they have lots of years of experience, oftentimes experience with their particular employer, and they may possess skills that are more sophisticated than younger workers simply because of the longer period of time they've had to acquire those skills. That means that they are in some senses different than we see for the other categories of discrimination, because in many cases, minorities and women may have lesser skills simply because of lesser opportunity. So we're looking at plaintiffs in a little bit different perspective when we're thinking about age discrimination plaintiffs. Again, we already talked about the need to have individualized evaluation. We try in this area of the law, just like we do with Title VII, to consider the particular person, not how the average 22-year-old functions or the average 57-year-old functions, but how this particular Bob and this particular Larry function. Okay, so let's get started talking about the Americans with Disabilities Act, which is oftentimes called ADIA. So again, this is our statute. If you don't already have this in Quizlet, I recommend that you add it. And of course, knowing that the 40th birthday is the important point in which you get coverage. So when you're 39 years and 364 days old, you are not covered by ADIA. But on your 40th birthday at 12:01 a.m., guess what? You're covered by the statute. So it's one of the few advantages to getting older. ADIA historically was created 3 years after Title VII. We can see it's 1964. You don't need to know this year for this class, but I think it's helpful to have a sense as to how our Congress acted in this area. And you can see that age discrimination wasn't quite as high a priority as the other categories of protection. It's interesting that Congress did not choose to simply amend Title VII and add the word age to the existing statute. I think that it chose to make its own statute because it recognized that in some sense age was a different category than the others. For example, age is something, God willing, that we will all achieve. But if we're born a man, we're likely to remain a man. If we're born white, we're likely to remain white. If we're born of a particular religion, we might change it, but very likely we won't change it. So these typically are more in the category of immutable characteristics that are pretty consistent through life. Age discrimination obviously would apply to people no matter when they're born. Eventually they'll get to be old enough, if they live that long, to experience age discrimination. Another reason that it's different is, as we've already noted, is that there's nothing inherently the case that will cause an African American to be more skillful or less skillful than a Caucasian, or that would cause a woman to be more skillful or less skillful than a man. But with the age factor, we can see that skills do diminish. Tom Brady at 30 is going to be more skillful playing football than Tom Brady at 60. The way that I keep the ADA straight from ADIA is that ADIA has an E in it, and the word age has an E in it. The ADA is about disability, and you'll see neither one of these words have an E in it. So that may be a little helpful reminder about how to keep those straights. ADIA has a little bit higher threshold for the number of employees the employer has to have before it applies. Again, this might reflect the fact that Congress saw this as a less serious problem than the types of protections it was addressing through Title VII. So, in order for an employee to be covered by ADIA, there has to be 20 employees for that employer. And again, our Title VII threshold is 15. You do need to know these two amounts. ADIA applies to government entities, also to labor organizations, and to employment agencies. This is very similar to Title VII scopes. We've talked about this in the past with respect to Title VII, but it also applies to ADIA, and that is U.S. citizens who are working for U.S. companies are usually going to be protected even if they're working in a foreign country. That's what we saw the rule was under Title VII. It's also the rule under ADIA. The word here is usually because, of course, if this country, the laws of the country that in which the employment is based somehow require some kind of age discrimination, then the ADIA would not apply. For example, if there's a mandatory statutory age in which you can't do whatever that kind of work is beyond that point, then the U.S. company would be free to discriminate. In fact, would be required to discriminate against the worker on that basis in order to comply with the laws of that particular nation. So let's look at the types of categories of employments that ADIA applies to. Apprenticeship programs, and this may surprise you because we usually think about apprenticeship programs as being something that starts a career. If you're an apprentice plumber, typically you're going to work for a few years alongside a plumber, learning that profession, that trade, and then when you have worked sufficient number of hours and received a sufficient amount of training, then you can apply to become a journeyman plumber. And so you might think, well, apprenticeship programs really should be for people in their 20s or possibly 30s, not their 40s. But the reality is that a person in his 40s or her 50s or 60s could also make an excellent apprentice. With the world in which we live in which there's constant shifting in the skill sets necessary for different jobs, and jobs that exist or may exist in 10 years from now may not have even been thought about today, that it makes sense to have a workforce that's constantly learning, constantly evolving. And so apprenticeships can't preclude people simply because of their age. Another thing to keep in mind is that job advertisements shouldn't focus upon a particular age, and there shouldn't be anything explicit or implicit in the ad that seems to prefer an age. So examples of terms that might be problematic would be things like ads that seek a college student. Well, certainly there are many college students who are in their 50s, 60s, and older. Usually, most college students are in their 20s and 30s. Similarly, recent college graduate again suggests a preference for younger employees. So you want to avoid that kind of language in ads. You also want to avoid any kind of inquiries before the employment begins that would indicate a preference. You don't want to ask, for example, dates of birth or dates in which somebody has graduated from high school or for college, because those might tend to indicate a person's age. You don't want to consider a person's age when you're making promotion or demotion decisions. Again, here there's a temptation sometimes when you're considering a promotion. You might think, oh, well, Bob is 65. He's probably about to retire. I don't want to promote him and then give him the additional training and then find 6 months from now he decides to retire. Well, again, if he's told you he's going to retire in 6 months, that's a different reason. That's something Bob controls. But if he hasn't told you he's going to retire, there's no reason that you ought to assume that he's going to retire at 65 or 75 for that matter. And so you ought to treat Bob, the candidate who's 65, the same way you would any other worker. He's going to work as long as he works. The 23-year-old on your staff may quit tomorrow for another position. So you shouldn't consider how long this person might continue to work as a factor in making promotion or demotion decisions unless they've given you information otherwise. Benefits should not vary for older workers as well. It is true that because of the increased likelihood of medical issues arising as a person ages, that the costs of the insurance may be higher, but that can't be a factor in making employment decisions. Once workers achieve the age of 65, they become eligible for Medicare in many cases. And so sometimes the benefits of employing older workers can actually be less than those who are younger workers. Obviously, we don't want to harass people based upon their age, but the same protections that are available to people to protect them from sexual harassment, race harassment, color harassment, religious harassment would also apply to age harassment. Usually, age harassment has the appearance of being kind of funny. People put up black balloons when somebody turns 60, or start calling people grandpa or the old geezer, or start saying things like, hey grandpa, you need help turning on your computer, that type of thing. It may sound funny, but I promise you, as somebody who's in her 50s, it doesn't feel very funny to hear that kind of thing. And while one stray comment every now and again isn't going to qualify as a age harassment claim, certainly a pattern of making those kinds of comments can ultimately become age harassment. Obviously, we can't have retaliation based upon someone complaining about either age discrimination or age harassment. So the same retaliation protections that exist under Title VII also apply to ADEA. As I said before, Texas also precludes age discrimination. Now, Texas age discrimination protections is in its statute that functions like Title VII. So we don't have two statutes under Texas law, just the one. And most states have a similar statute as well. The idea does not apply to members of the armed forces, and that makes sense because of the physicality of the military lifestyle. It's hard to imagine somebody in his or her 70s being a frontline soldier in a pitched battle. It wouldn't be fair to that person. That person wouldn't have, the ability to be successful in the battles at that point if it were a physical type thing. On the other hand, older workers might well be able to fly drones, analyze data, do many things behind the scenes in a very effective way. But the majority of the actual fighters are going to need to be people typically, below the age of 40. And so the IDEA doesn't apply to them. There are also certain public safety employees in which ADEA does not automatically apply to. These are often police officers and firefighters. Again, there may be less safe for older individuals to perform those tasks, and cities and local communities and states have the option to have mandatory retirement ages under those circumstances. In addition, we have that companies can have mandatory retirement ages in very specialized circumstances. When we're talking about a bona fide executive, as long as that particular employee will receive a pension of at least $45,000 a year. If it's less than that, then you cannot have a mandatory retirement age or demotion. And you can't have a mandatory retirement age of under 65. Most companies don't choose to take advantage of this category, but it is available, again, for just the highest people within an organization. We'll talk more about this later. So a big difference, and probably one of the big differences, or one of the reasons why ADEA has its own statute versus being just age being a part of Title VII, is reasonable factor other than age, which is usually called RFOA. This defense is kind of like the business necessity defense that we saw with disparate impact, but it puts quite a bit more significant burden on the plaintiff. We'll talk more about that as we progress in this unit. An employee is not, when we talk about prima facie case in Title VII cases, it's usually necessary that the person who replaces us was of a different race, if it's a race claim, or a different national origin, if it's a national origin claim, or a different sex, if it's a sex claim. But for age claims, it's not necessary always that the person who replaces the older worker actually be under the age of 40. Because let's look at this example here. So Mary is 59. She's employed as a makeup artist. The company has a new manager, Bob. Bob fires Mary and gives the job to Susan, who's also over the age of 40. So they're both in the same protected category, but we certainly recognize that there's a difference between 42-year-olds and 59-year-olds, 17 years. And so there can be age discrimination even within the 40-plus age category. So because there is a significant age difference between Susan and Mary, Mary very possibly does have an age discrimination claim. Now, if Susan were 55, I would say probably not. Oftentimes about 7 years is the amount of years that we look to see if there's a claim. 7 years is about the minimum that you would expect to see a claim. A more robust claim would be probably 10 or more years. So it's not necessary, again, for Mary to prove that Susan is younger than 40. Now, of course, if Susan were 59 and Mary were 42, then Mary would be advancing a reverse age discrimination claim, even though she herself is over the age of 40. And that type of claim will not fly. We'll see some more about that later on. So let's imagine that you are 39 and a half years old and your manager comes to you and goes, "You're out of here, Bob. I know you're about to turn 40 and I just happen to hate 40-year-olds. And I know I can't fire you once you have your 40th birthday, so I'm firing you now. So get out of here." You might think to yourself, well, surely that's illegal. No, it's not. It's okay to fire somebody because they're 39. You can fire them because they're 39 and 364 days old if you want to. Just when they have their 40th birthday, it becomes unlawful to fire them. So discrimination against 39-year-olds because they're 39 is not prohibited. Now, obviously, if they fall into another category, for example, you're firing them because they're 39 and because they're African American, or you're firing them because they're 39 and they're a woman, that would be unlawful. There are record keeping requirements under the ADEA. So that's if you are especially in-house with an employer, you'd want to make sure you're complying with all the EEO-1 and other documentation that's necessary in this area. So let's consider the issue of sovereign immunity. Sovereign immunity, we haven't talked a lot about this in this course, but that is the rule back, if you go back to say English times, back when there was a king who controlled things. He, of course, or she for that matter, was the sovereign, was the ruler. And the sovereign or the ruler was not able to be sued. He or she could kind of do whatever he or she wanted. He or she was the law. And so we call that idea sovereign immunity. And as a result, you couldn't sue him or her, which basically meant you couldn't sue the government. Well, that idea continues even though we're a democracy without a king or queen. You can't sue the government, be it state, local, or federal, unless the government has given individuals permission to sue the government. Now, the reality is the United States is most of the time you have been given permission to sue the government. And it's not permission on an individual basis, but it's actually permission in a statute. And so in those cases, once you have permission, you can go ahead and do that. But it's possible that in some states, some state workers haven't received the permission to sue their state government. But in Texas, you do have that permission. So let's consider this scenario. Bob's 57, so he's clearly within the age category. He's employed as a school bus driver. He has a great record. He's been doing it for 27 years, but he's fired, and Bob, who's only 31, replaces him. Under those situations, Bob decides to file a claim under ADEA with the EOC If Bob lives in a state that isn't Texas, that hasn't waived sovereign immunity, Larry may not be eligible to advance his claim. Now, this is different from Title VII, where the federal government has waived the sovereign immunity under those situations. I'm giving this to you just an example, but since it doesn't apply in Texas, it's not really important to the course of or to the scope of this course. We'll talk more about remedies as we proceed in this lecture or in the future lectures, but just be aware that there are different remedies available to successful plaintiffs under ADEA versus Title VII. And again, that's another reason why ADEA is a law that's separate from Title VII. So let's consider this case. It's a U.S. Supreme Court case. Can an employee file an age discrimination suit under ADEA if his replacement is 40 years or older? Well, we already know the answer to that question because we saw that question under this scenario here. And so the answer is yes. Just going to go through here quickly and see that yes, age discrimination can occur even if the replacement is age 40 years or older. In this particular case, I guess we don't actually see the ages. Well, maybe we did actually provide the ages. Yes, the person suing was 56 and he was replaced by a 40-year-old. So there was 16 years gap. Certainly quite possibly sufficiently different to imply that there may be age discrimination in play there. You don't need to know the name of this case. I'm just offering it as an example. Let's look at the next case, general dynamics. Does the ADEA prohibit reverse age discrimination against workers over the age of 40 by providing benefits that are more favorable to a class of older workers? And in this case, there's workers between 40 to 49 were denied a benefit that workers over 50 got. So Mr. Klein, who was in this age category, sued saying we ought to be able to get what the older workers, the ones older than us, are getting. But no, the court said it's okay for an employer to treat workers who are older better than they're treating other workers who are still over 40 but are younger. ADEA does not stop an employer from favoring an older worker over a younger worker, even if the younger worker is over 40. And again, you don't need to know the name of this case either, but you do need to know the concept. State laws for age discrimination do vary significantly. It's the one area that we do see differences. We don't see a lot of differences with race or color or sex or religion. Those categories, the protection's usually the same from state to state. But in the various states, some states do recognize reverse discrimination, or some states do have a different age level for when discrimination is considered to have begun. Texas, though, is probably the most common model in that our state statute really tracks ADEA. The 40 years is a starting point, and there is no reverse age discrimination claim recognized under state law. Again, these I'm trying to show the variations that we have under different state laws, but again, in Texas, the state law tracks with the federal law, so we don't have to be overly concerned about this. I like to flag this, though, because you may choose at some point in your career to live in a different state and to practice there, or perhaps even more likely, you may work for a corporation that has branches in other states, or you may work for a law firm that has clients that have branches in other states. So obviously Texas law is the most important to us in Texas, but it may well not be the only area that you need to look into. Okay, when I was working at JCPenney, I typically covered states in the southern part of the country, the southeastern part of the country, from Texas and Oklahoma going east from that point. So I'm most familiar with those, but I also spent a lot of time learning about Wisconsin law, Connecticut law, Kansas law, Pennsylvania law, somewhat Utah and Nevada law, and somewhat California law, less so on that one. So again, depending upon the states that your clients are in, you're going to see different emphasis. And so it's helpful to kind of know where the issues are in other locations. Let's talk about the process of filing a complaint under a DIA. It's a little bit different than Title VII. So the first thing that can happen, and this also can happen under Title VII, is that the employee can file an internal complaint within the organization. Many times this is a very effective way of resolving a concern. It may be that the manager is doing something and once somebody in HR knows what's happening, the person in HR can fix it. Or perhaps there's been a miscommunication, or once the concern is expressed, people look at it more carefully and realize that the problem needs to be resolved. But sometimes that doesn't solve the problem. And so there's going to be another opportunity, which is to go to the EEOC. This is the same agency that handles Title VII, the um, Equal Employment Opportunity Commission. Or you can go to your state FEP agency, which is often called a 706 agency. Our 706 agency in Texas is the Texas Workforce Commission. Its only office, though, is in Austin. So most of the time in the North Texas area, when there's a discrimination claim filed, it's going to be filed with the EOC because they have an office in Dallas. It doesn't matter which one you file with because they're considered jointly filed if it's an age discrimination complaint. One thing you don't want to do if your client is filing an internal complaint is wait to file the EEOC complaint, because the filing of an internal complaint does not stop the ticking of the clock on the 300 days for the EEOC complaint. Let's see. Let's discuss the lawsuit. So you can file an ADIA lawsuit anytime after 60 days from filing the EEOC complaint or charge. This is different than Title VII because remember, under Title VII, you have to wait for that right to sue letter to issue. Now, it might issue right away, so it might issue from the EOC in less than 60 days, or it might be quite a bit longer. Oftentimes, the EOC is willing to issue a right to sue letter if the plaintiff requests it, but the EOC doesn't have to do so. So unlike Title VII claims for ADIA, you don't need to have a right to sue. You do have to file the complaint, but you don't have to wait for the right to sue letter to issue. And let's talk about prima facie case. We've talked about this a lot, so I'm not going to dwell. I'm really going to focus on what the differences are between the prima facie case for a Title VII claim and for the age discrimination claim. Just like we have under Title VII, we do have disparate treatment age claims and disparate impact age claims. The disparate treatment category is pretty similar to what we see with Title VII claims. The disparate impact is a little bit more different. So let's first of all focus on disparate treatment, see what that looks like. So we have our prima facie case. The first is that the plaintiff is within the protected age group. So the plaintiff has to be 40 or older. And this is similar to what we've seen with Title VII. We don't have the reverse category as we do with Title VII, but we do have the requirement that the person demonstrate that he or she fits into the category that is relevant. We also need the plaintiff to prove that he or she is qualified for the position. Again, this is usually not a dispute because most age claims, just like most Title VII claims, arise when the person is dismissed from the position. But it can be relevant whether the person was qualified if the person were applying for the job. And then we need the third qualification, which is the person was adversely affected. Typically, this is going to be dismissal, but it could be failure to hire, failure to promote, or it could be a demotion situation. And then the fourth element is that kind of catch-all that we talked about before. And this is going to mean that the employer sought or retained someone else who was significantly younger. Doesn't have to be someone under 40, although that's a good fact. Now let's imagine for a second that Bob is 42 when he is terminated, and the person who replaces him is 39. You might think, well, that you've proven prima facie case. Bob is over 40 and the person who's selected is under 40. But if there's only a 3-year age gap, I think that the court may well say that's not a sufficient evidence to establish the prima facie case. So significantly younger isn't going to be merely satisfied by the person being under 40 when the person who's filing the claim is just over 40. We've seen these terms before, but here's a refresher. Qualified for a position means that the person is able to meet the employer's legitimate job requirements. Now, this can be a little bit complicated because an employer might have unreasonable job requirements, perhaps intended to discriminate against somebody. We talked about this in the race discrimination section when we said, well, what if an employer requires, I don't know, its janitors to have college degrees? That doesn't seem like a legitimate job requirement. But if an employer didn't want, say, African Americans or Hispanics to be employed in that position, they might put unreasonable requirements in the hopes that they would attract, I don't know, if they wanted Caucasians to be in that role, they would attract Caucasians for that role. So the employer doesn't get to just say, well, we're going to establish the qualifications and that's the end of that discussion. The qualifications do need to be reasonable under the circumstances, and there can be some inquiry if an employer sets up unreasonable job requirements. An adverse job action is, or employment action is just what we think it is. It is when uh, something is taken away, a benefit, an opportunity, or a privilege of employment. Now we're going to talk about uh, the topic of reasonable factor other than age. We talked about this briefly before, but let's spend just a little bit more time talking about this. Um, Reasonable factor other than age is similar to the non-discriminatory reason that an employer might have for making a decision. You know, when we talk about the ping pong ball, you know, under Title VII, the employee makes the prima facie case, then the employer, the ball's in the employer's court to make a response, something like, well, we didn't fire Bob because he's African American. We fired him because he was perpetually late to work. And then Bob is going to have an opportunity to show, well, yeah, I was late to work a lot, but Sam, who is white, was late to work more often than I was, and he wasn't dismissed. And so this reason over here, this non-discriminatory reason in a Title VII case is similar to what we call the reasonable factors other than age in an age discrimination case. But it's easier for the employer to prove the RFOA defense than it is the employer to disprove the prima facie case. The reasonable factor other than age defense includes any requirement. I don't know if I have a definition. Probably I have one coming up if I haven't yet. But if we don't have a definition, this one might be the one to use. So reasonable factor other than age defense includes any requirement that does not have an adverse impact on older workers, as well as those factors that do adversely affect this protected category, but are shown to be job related. And again, this goes back to the idea that unlike race and sex and national origin, people as they get older can have a diminution of a particular skill. So, for example, if there was a job that required very fine motor skill and very sharp eyesight, perhaps a surgeon, for example, you might require that that person pass a vision test or a manual dexterity test. Um, Somebody who's 70 might be unlikely that that person will pass the test, but the average 38-year-old might be able to easily pass that test. So that would tend to show that test would adversely impact, it would have a disparate impact upon people based upon age. But if you show that particular set of skills is job related, then it would be considered a reasonable factor other than age. Of course, we wouldn't see that in race or national origin categories because there aren't skills that African Americans are usually better than white people, or white people are usually better than African Americans. So that particular aspect of difference between the categories just means that RFOA makes sense for age, but that same logic really doesn't apply to Title VII claims. Let's consider a few scenarios here. So this company is merging in with another company. As a result, the companies kind of decide to do a reduction in force. Bob's job is eliminated. He's 51 years old and he thinks he was targeted for his age. The new company can defend Bob's claim of age discrimination if it can provide a reasonable factor other than age for Bob's termination. Now we can see Bob is going to be able to prove his prima facie case because he's over the age of 40. He was doing his job of production manager, so presumably he was qualified for it, and his job was eliminated, which of course is an adverse employment action. So he satisfied all of the elements other than this last element that he was replaced by someone younger. But presumably, other people who were younger were retained. And so that could be the basis of Bob's fourth element of his prima facie case. Let's consider the next scenario. Bob worked for stork delivery service for 35 years. So he would load trucks, drive trucks, handle items over to the recipient. He's 60 years old and was recently fired. Stork delivery service will prevail if it will show that Bob's vision had declined such that he could not safely drive. It's not Bob's fault his vision had declined. That's a factor of the aging process. But if he would be more likely to be in car accidents as a result of his decline in vision, then Stork could act on this RFOA and make that employment decision against Bob. Gross is a difficult case to make sense of. We're not going to spend a lot of time on it because it is such a dense case to unpack, but I do want to briefly go over it. If you're thrown by it, just keep in mind that this is not going to be a major issue, on any future test or something for you to be excessively concerned about. So Gross says that there's no burden shifting in ADEA cases. The plaintiff has to prove age discrimination was the but-for reason. You may recall when we had the Costa case, we talked about mixed motives and how sometimes there can be lawful reasons and unlawful reasons. In this case, the burden always remains with the plaintiff, unlike it switching over to the defendant. Age has to be the but-for cause for the action. So it could be, again, going back to this case, it could be that Bob's age was somewhat of a factor, but his real age, the real reason was that he was tardy to work a lot, and that was the main reason he was dismissed. That even if he had been 37, he would have been dismissed if he had had that tardiness history. Now, Bob may be able to show there were some emails sent that said, we don't know somebody who's 60 years old if they're really up for this job. So Bob has some good evidence there. But again, if the employer can show that Bob was perpetually tardy to his job and that the employer had taken similar action against younger workers, then very likely the employer is going to be able to show that the but-for reason for the action wasn't age discrimination, but it was, tardiness or something along those lines. We don't have true mixed motive claims. So I shouldn't have the S there, under ADEA like we do for Title VII. Let's see if there's anything else I want to focus on. So when we talk about majority here, just so you'll understand this is referring to the gross majority, to the courts, the members of the Supreme Court who decided this case. And the point that they're making is that Congress had amended Title VII to allow for a mixed motive type theory, but Congress had not chosen to amend the Age Discrimination Employment Act when, of course, the Congress would have been free to do so. So the Gross Court decided, the U.S. Supreme Court in Gross decided not to extend the logic of the changes in the statute to another statute. And this is Gross. Okay, so you can see this is a 2009 case. When there is evidence for an age-related motivation and another motivation, which is an age-related, how does the burden differ under ADEA in comparison to Title VII? And that's again what we were talking about. The Supreme Court held that it is the plaintiff who must prove that age was the actual cause, the but-for cause for the employer's action. So mixed motive cases where the burden shifts to the employer is not going to be the case with age claims. So even when the employer produces some evidence that age may have been a motivating factor, it's still going to be on the plaintiff to reach that final burden of proof that uh, the employer would have taken a different action if it hadn't been for the age discrimination. So that's a kind of a fine tune there. Again, you don't need to know the name of this case. Really, what I want you to leave from this section is that a reasonable factor other than age is a lower threshold for the employer than the prima facie case rebuttal that employers usually need to make under Title VII. And also, the mixed motive cases are harder for plaintiffs to win, age discrimination plaintiffs to win, than Title VII plaintiffs to win. Okay, so we've talked about the prima facie case that the employee has to make. Then we've discussed the employer's reasonable factor other than age response. And now we're back to the employee's response to the employer's response. And of course, one thing to keep in mind is that if the employee presents direct evidence of discrimination, we don't even really think in terms of prima facie case or this kind of back and forth ping pong ball. So if there's like an email that's learned about in discovery in which somebody says, we want to get rid of Bob, he's just too old to work there anymore. That's pretty darn bad. There's not a lot you're going to be able to do if you're the employer in that situation. And but usually that's not going to be the case, or at least I hope that's not going to be the case often. And so the employer is going to be able to present what it thinks is a reasonable factor other than age, and the employee is going to come back and say, well, and here are some responses the employee can have to refute that. One is, that's not true. That's not true about me. I didn't have that attendance record. Or I was hardworking. You're wrong when you say I wasn't hardworking. So they can basically say employer is lying or has misunderstood the evidence. Another thing is the employee can say, well, yeah, that may be true, but that's not why the employer took this action. And a good way for the employee to make that response is to use comparators. I had the same attendance record that Sally had. Sally was 35. She wasn't dismissed. And then a third thing you can say is that, well, the reason the employer is offering just, it doesn't seem sufficient. Really? Somebody who was tardied only 3 times you're going to fire? That doesn't make sense. That doesn't seem logical. And if it doesn't make sense, then perhaps the real motivation was something like age discrimination. Okay, so now let's talk about Hayes and Paper. This was a pretty big case, no doubt about that. I'm not going to ask that you know about this case, but this one was a surprise, I'm going to tell you. When it came down, I think most legal scholars were thinking it would have gone down the other way. In this case, there was a reduction in force, and reductions in force are especially uh, when you are supporting your client who's going through reduction in force. Age discrimination is a major, major concern. Uh, it's very difficult to get the numbers, the statistical surveys that you do in those types of cases to not look like they're age discrimination. The numbers invariably look like they're, from a statistical standpoint, that there is some age discrimination going on. And so there was a lot of concern about among the bar, the defense bar, about how this would play out when this case came up. Uh, the case ended up being very positive for the defense bar, not so positive for the plaintiff's bar. But it still doesn't mean that plenty of age discrimination plaintiffs who lose their jobs due to a reduction of force can't have very successful complaints or very successful lawsuits. But this case was a victory for the defense bar. So in this particular case, the court said there is no disparate treatment when the motivating factor is some feature other than an employee's age. In the Hayes and Papers case, the company laid off people or laid off a person who was about to vest under a pension benefit. It's a really sad story, to be honest with you. Maybe it was a 15-year vesting period or something like this, and they took away his job right before he reached that threshold in which he would be able to get these generous pension benefits. And that was the reason that they did it, because they didn't want to have to pay these benefits. So, but of course, the flip side of that is somebody who had enough service to be almost eligible for the benefit will typically be an older person. It's relatively rare for someone to be with a company for 15 years and probably not also be over the age of 40. I mean, it can happen. You can go to work at a place at age 18, but usually the person is going to be in his or her 40s or older. And so you might think, well, years of service somewhat tracks with age of employee. Obviously, if you've worked in a place for 40 years, you're obviously going to be well into your 40s. You can't, well into your 50s actually. And so there is some relationship between the two of them. But the court said, no, yes, I mean, statistically, there's some relationship between the years of employment and a person's actual age, but they are logically distinct categories. Now, in the Hayes and Paper case, it is helpful to keep in mind that terminating somebody because they're about to vest in an ERISA program is a Section 510 claim. So Biggins still did have a claim. There was still evidence of a violation of the law, but it was a less lucrative theory that Biggins might have been able to advance. Okay, in 2005, the U.S. Supreme Court found a disparate impact theory can exist in theory under ADEA, but the court said it didn't exist under these facts. Given this analysis in this case, it seems unlikely there's going to be a lot of disparate impact, successful disparate impact ADEA claims. And again, that goes back to the idea that people, here we have our definition for reasonable factors other than age. Because people are going to have some diminution of their skills. So here's our definition. A reasonable factors other than age may include any requirement that does not have an adverse impact upon older workers, as well as those factors that do adversely affect this protected class but are shown to be job related. So this is actually the same definition we had on the other slide. And again, there is the RFOA idea. It doesn't exist under Title VII. So this is what the EEOC says about RFOA. There has to be a relationship between the factor and the business purpose. So again, companies can't just randomly say, oh, we suddenly care about vision, even though there's no particular reason a person needs to have good vision for this job. Or we suddenly care about how quickly a person can run, even though there's no need for a person to run in this particular position. So there has to be a logical relationship. The factor has to be well defined and consistently applied to everybody. And it can't be based upon subjective discretion. For example, well, that person's a hard worker, that person's not. Well, how are you evaluating? Well, I just notice, whenever I look, that person's working hard. Whenever I don't look, that person's not working hard. Well, if the supervisor happens to have assumptions about people at a certain age, maybe he thinks, well, all older people are slower. And so because he comes into the employment situation with that assumption, that's what he perceives as happening, even when it's not happening. And so you want to be able to quantify it. If Bob who's 50, really is a slower worker than Tom, who's 30, then Bob will be producing less work, and you ought to be able to measure that. The RFOA standard is less demanding of employees than the Title VII's business necessity defense that exists under disparate impact Title VII claims. Again, this is just a definition of disparate impact. So here's an example of how a disparate impact claim could work under age discrimination. Again, this is not one that we've seen successfully often, but this is how it might look. So Bob's 62, he applies for a job at this company. The company really doesn't want to hire people over the age of 40 because the job is a strenuous job and they just don't think people over 40 are going to be able to handle it. So instead of having, say, some kind of endurance test that would fairly measure a person's ability to, or maybe a weightlifting test to see if a person can manage the heavy fishing nets that might be involved in a perch fishing activity. Instead of doing that, they decide to implement a vision test. Maybe they chose this because they thought it would be easy to implement. And what they're hoping is, they think to themselves, well, people who are older probably don't have as good a vision as younger people, so we're going to require everybody to have 20/20 vision, hoping that all the older folks are going to fail the vision test, and so they don't have to hire any of those older folks. But of course, you probably don't need to have great vision to be a fisher person. At least I'm guessing you don't. I'm not sure. But let's assume you don't have to. And so this vision test really wasn't designed to measure a relationship to a business, to a legitimate business purpose. And as a result, it would be a disparate impact that could very likely cause Bob to be able to advance a disparate impact age discrimination claim. As we've talked about in the past with Title VII, statistics are your friends for you if you are trying to use a disparate impact analysis. But they're harder to use in an age claim than you're going to have in a Title VII claim because of the natural attrition in the workforce. You don't have as many 70 or you don't have as high a percentage of 70-year-olds working as 50-year-olds working. And so it's going to be harder statistically to see, well, uh, uh, you would need to make sure that you're comparing apples to apples. So for example, let's say, I'm making up numbers here, let's say 10% of the workforce is between 50 and 60, and only 3% of the workforce is between 70 and 80. Well, then, let's say in this particular place of employment, we see that 8% of the workforce is um, between 50 and 60, but 4% of the workforce is between 70 and 80. Well, that would make me think that this was a pretty well represented workforce, having such a high percentage of 70 plus workers working, even though the percentage is actually quite a bit smaller than the percentage of 50-year-olds working. We're not statisticians in this course, but if you get to the point where you're actually doing a lot of disparate impact work, you'll need to become familiar with statistics. And so 2 to 3 standard deviations is usually what the Supreme Court is looking for to see some kind of suspectness in the actual composition of the workforce in order to test for that disparate impact. And again, you have to consider all of the requirements. If you were looking at a football team, a professional football team, you're not going to find many 60-year-olds on that professional football team. But that doesn't mean that the professional football team is discriminating against 60-year-olds. It's just simply a fact that 60-year-olds are unlikely to have the stamina and the physical strength necessary to play professional football. So again, context is going to be crucial. This is a pretty neat chart if you're kind of lost in this area, and we've gone through disparate treatment, disparate impact, but you'd kind of like one cheat sheet to make sense of this. I think this slide is a useful one. And so let's go through it for a second. So we have on one side the disparate treatment category, and on the other side the disparate impact. So disparate treatment, again, we have that ping pong ball that we've talked about before. We start on the employee side of the net, and here is the prima facie case. And then we go over to the employer side. It gets to respond. Here are some examples of things that it might advance. And then the employee gets another shot at saying, oh no, that's a bunch of hooey. That's not true, or that's not the real motivating reason. Then once you, or if you have, instead of a disparate treatment case, but disparate impact case, then here is the prima facie case we're looking for here. A facially neutral policy or rule that the employer has created, which has a different effect on older workers, statistically a more bad effect, obviously. And it has to be statistically significant, but there is no need for there to be an intent to discriminate. And again, here we have the reasonable factors other than age, which can include things like economic concerns or seniority. There could be lots of other items on this list as well. So here we have both theories, I guess, of the case. We've already discussed mixed motives. Let's go through some employer defenses. We have the bona fide occupational qualification, which we'll talk about in a couple more seconds. Similarly, employers are allowed to use a bona fide seniority system. Actually, seniority systems usually benefit older workers because obviously you have to be older to have worked a lot of years for a particular company. Just just like we saw with Title VII, if there is a valid compulsory arbitration agreement, that can be binding on the employee, just as in the ADEA situation, just as it is in the Title VII situation. And of course, if the employer had good cause to take the action they did, that's a defense. For example, if Bob is 75 years old and he's stolen from his employer, the employer can say, I didn't fire Bob because he's 75, I fired him because he stole. That's a pretty good cause. Then employers can, and from time to time do offer voluntary early retirement programs to motivate workers to leave. That can be an alternative to doing a reduction in force. It's a little bit more humane, you could say. And employees who choose to take advantage of it, because after all it's voluntary, are going to not be able to then turn around and sue. If they want to stick around, they have that option. Also, workers who weren't eligible for the voluntary early retirement incentive, but who are, say, too young for it, can't sue. Now, if an employer were to have a voluntary early retirement program, but were to exclude workers older than that, for example, to say you have to be 60, between 50 and 60, for example, the people who are 49 are not going to be able to successfully sue because they were excluded. But the people who are 61, yes, would be able to sue because they were excluded if they would have otherwise been eligible for the program. We've already discussed reasonable factors other than age. We'll talk more about voluntary and knowing waiver of rights under the Older Workers Benefit Protection Act. That's an important law that just applies to ADEA plaintiffs, doesn't apply to Title VII plaintiffs. There are additional things that have to be in that waiver if the employer wants to release claims related to age discrimination. We had that executive exemption for those workers who are expecting at least a $44,000 pension a year. And then, of course, we have the safety workers who sometimes are excluded or sometimes can have a mandatory retirement age, people like firefighters and police officers. Now we're up to the bona fide occupational qualification. Just like we saw with sex and religion, you can, and national origin, you can have a bona fide occupational qualification for age. It's not quite the same wording that we see in Title VII. It's a little bit more open-ended, a little bit more allowing exceptions to it. So it's a little bit easier for an employer to fit into than we see with Title VII. But in order to make a BFOQ, the age limit has to be reasonably necessary to the essence of the employer's business. In addition, all or very close to all of the employees over that age have to be unable to meet the job's requirements adequately. And then finally, it's hard to measure that without using age. It's hard to sort through the populations in a way that is going to allow you to separate the folks who are still able to continue working and the folks who are not able to continue working. And the big case here is Criswell. And the question is, that we're looking at is what must an employer do to support a BFOQ based on safety considerations? And of course, we're talking about in an age case. So in this case, we had, or this particular airlines required, I guess in an age claim, this particular airline required that all airline flight engineers, these are people who are in the cockpit, retire at the age of 60. Many at that point, they were still eligible to have pilot license, and the FAA did not have a problem with these engineers continuing as flight engineers. But a Western airline said, well, we don't feel like they are sufficiently safe, or at least there's some who aren't going to be sufficiently safe. We don't want to risk our airline and our passengers being in a dangerous situation. We want to err on the side of safety. We recognize some of the people who are 60 and 61 who are flight engineers would be able to do it safely, but we just can't figure out any way to sort through the safe ones from the unsafe ones, so we're going to exclude them all. The expert testimony at trial said both things. Some said they were safe, some said they weren't safe. So the U.S. Supreme Court concluded that the employer must conduct individualized evaluations of employees based upon their merits, not their age. So if the concern is that they're going to have a heart attack, let's do some EKG monitoring or some monitoring along those lines, blood pressure monitoring. If the concern is about vision or stamina, then you can test those things, but you can't just have a blanket rule. Of course, if the FAA had a policy that said workers, flight engineers at the age of 62 lose their license, then Western Airlines would absolutely be able to apply the 62-year-old rule to that case. So this issue only went to the Supreme Court because the FAA had not precluded these workers from working at the age of 62. So here are some additional defenses that are based upon benefit plans and seniority systems. So bona fide retirement options can distinguish between workers based upon age. So if you offer greater benefits to workers who are 65 than those available to people who are 64, that's perfectly okay. Bona fide voluntary retirement options do have to truly be voluntary. Sometimes they can feel less voluntary, especially if the company is failing. The person might be thinking to himself or herself, well, if I don't take this package, I may just be fired or, riffed without any package. And so you have to consider the totality of the evidence or the information at that time to decide whether it's voluntary or not. Now, when I say voluntary, I don't mean simply that no one's putting a gun to your head, but voluntary in the sense of there really is a realistic likelihood that the employment could continue if the person didn't opt for the package. The same actor defense is available in an ADEA case. It's available as evidence in a Title VII case, but it doesn't have quite as much strength in a Title VII case as it does in an ADEA case. And when I say the same actor, I mean the person who hires is then the person who terminates. Well, the idea is, well, if you hired an older worker, why would you then turn around and fire them because they are an older worker? So in this situation, Bob is hired at 46. He works for the company for 5 years and he's terminated by the same person who hired him for poor performance. Probably the same actor defense is going to apply in that situation. Because Mary hired him, obviously, maybe not knowing technically his age, but probably having met him and having a pretty good sense as to his age, and now she's choosing to fire him. Now, again, it's still powerful evidence in a Title VII case. Let's imagine the facts were different and Bob is an African American. Mary hires Bob, obviously knowing he's African American. Well, 5 years later, Bob is still African American, and so it seems unlikely that Mary would suddenly have decided to discriminate against Bob because of his race. So it's still powerful evidence in a Title VII case, but it doesn't have quite the slam dunkness, I guess you could say, about it as it has in the ADEA world. Okay, so let's consider this case. Is an employer using a pretext when it hires a much younger, inexperienced candidate over an age-protected, experienced candidate? And the answer is not always. It's not always going to be pretext. I don't like this case. In my opinion, it's not well reasoned. Uh, Pugh was a very experienced person in the field, and he submitted his resume. The employer actually interviewed four other people, didn't interview Pugh, and they were all younger and had less qualifications. Pugh doesn't get the job. He decides to file a charge. And the insurance company said, well, we're not hiring Pugh because he's overqualified. And the concern that companies sometimes have in this situation is if we hire Pugh um, in a position to which he's overqualified and probably being undercompensated, he's going to leave us pretty soon because he's not going to be satisfied with this employment. And then we're going to be back in the same position of trying to find a job, of trying to find somebody to fill this job. Another possibility is that if Pugh does stay in the job, he may be disgruntled or unhappy working at a position that's inferior to his skill set. And in that situation, he may work less conscientiously, he may have a less positive attitude. Those are the arguments advanced uh, that employers say why they don't want to hire people that are overqualified. But of course, the flip side is for workers who are like Mr. Pugh. I think his age was, well, we don't actually have it here, but since he had worked in the industry for 30 years, he probably was at least in his 50s. He would say, well, overqualified is just a fancy way of saying age discrimination. But in this case, the appeals court accepted the employer's explanation that it did not interview Pugh because his application was unprofessional in appearance and his background was not exactly what they were looking for. You don't need to know the name of this case. Again, it's very fact specific. Maybe Pugh's resume did have typos in it or other problems, and that was a real factor. Obviously, the EOC took the case for Pugh, so they thought they had a good case. So, not a big fan of this decision myself from a legal standpoint. Okay, so let's consider some special concerns when we're talking about ADEA litigation. As we said before, if there is an arbitration agreement that's pre-existing, just like under Title VII, that is very likely to be enforceable most places and certainly in Texas. In addition, collective bargaining agreements can require that age discrimination claims be arbitrated, even if the particular person didn't actually sign it. You know, again, a collective bargaining agreement is between the union and the employer. The individual employees don't sign that. Another difference, and we haven't talked a lot about class actions here in this course, but I'll touch on this a little bit because this is an interesting, there are two categories of class actions that we see, the opt-in and opt-out ones. Title VII is an opt-out one. And what that means is once a class action is established, all the potential members in a Title VII universe, when the claim is a race claim or a sex claim or a religion claim, all the relevant class members are assumed to want to be a member of that class. So let's say you work for a company that has 1,000 employees, and 100 of those employees are African American. And you are the plaintiff, you are African American plaintiff, and you are wanting to establish a class action. And so you talk to 3 or 4 of your colleagues who are also African American, and y'all decide to sue on that basis. But you want to sue for all 100. You don't even know all 100, but you think that all of them have been subject to some type of discrimination. And so what would happen is you'd obviously after you get the law firm, you would then file the lawsuit, and then through the discovery process, you would find out all of the 100 people who are African American working for this particular employee. And if those particular workers don't do anything, the assumption is they want to participate in the lawsuit. They have to actually do something to opt out. They can. They can say, well, gosh, I don't think anything happened to me. I don't think I was discriminated against. I don't want to participate in this lawsuit. So I'm telling you, don't litigate my case. Or the person might be saying, you know what, I want to do my own lawsuit. I don't want to be a part of this lawsuit. So I'm opting out because I want to sue on my own behalf. But you can see either way, the assumption is the person wants to be part of the class action. They have to do something to leave it. So for a class action under the Age Discrimination and Employment Act, it's the opposite. Potential plaintiffs have to opt in. So again, let's return to that same workforce. We have 1,000 employees, 100 of them are over the age of 40. You're over the age of 40. You feel like there's some systematic discrimination against older workers. You file a class action on their behalf. You're going to have to persuade as many of those people as you can to join the class action. If they don't do anything, the assumption is they don't want to participate in the class action. They won't be a part of it. They have to directly opt in order to participate. So that's a little bit of a difference between other types of class action. There's a rule, the Federal Rule of Civil Procedure, Rule 23, is what usually establishes how class actions proceed in federal court. But under ADEA, the rules are different. The Rule 23 doesn't apply. At this point, we've covered about half of this module. We've given a little introduction to age discrimination. We've talked about what is required under the Age Discrimination and Employment Act. We talked about the complaint procedure for advancing an age discrimination claim. And then we discussed the prima facie proof required, especially the reasonable factors other than age requirements under ADEA. At this point, we're done with our presentation for today. In our next lecture, we'll discuss reductions in force, retirement, and the Older Workers Benefit Protection Act. I hope that this presentation has been helpful for you. If you have questions, please feel free to stop by my office hours. I'd be delighted to talk to you in more detail about it. Thanks for your attention. Have a wonderful day. Take care.